Hello everyone, I'm Aratrika Bhaumik and welcome to LiveLaw. In a crucial hearing, the Supreme Court today stressed on the need to create a balance between the welfare of the state and the economic strain on the public exchequer while considering a plea seeking issuance of directions to the Election Commission of India to ban political parties from promising freebies to lure voters in the run-up to elections. The Chief Justice of India, RAMANA, remarked, and I quote, "Economy losing money and the welfare of people both have to be balanced. That's why this debate, and there must be someone to put thoughts to the vision." Pertinently, the bench comprising CJI RAMANA and Justice Krishna Murari underscored that the court will not look into the aspect of deregistering political parties for distributing freebies, as it will go against the principles of democracy and thus cannot be permitted. To provide a brief context, the Supreme Court was hearing a public interest litigation filed by BJP leader Ashwini Kumar Upadhyay seeking directions to the central government and the Election Commission to take steps to regulate poll manifestos of political parties and make political parties accountable for the promises made in such manifestos. The PIL also sought directions to the Election Commission to invoke its powers to freeze the election symbols and cancel the registration of such political parties. On August 3rd, the Supreme Court had opined that an expert body consisting of various stakeholders such as the Niti Aayog, Finance Commission, Law Commission, Reserve Bank of India and members of ruling and opposition parties would be required to give suggestions to address this issue of promise of freebies during election campaigns. To enable the court to pass an order for the constitution of such a body, the court had directed the petitioner, the central government and the Election Commission of India to give their suggestions. However, subsequently, the Election Commission of India had taken a stand before the court that it is not within its mandate to regulate the policies which a party might adopt after getting elected. In a supplementary affidavit filed, the Election Commission of India had declined to be a part of the expert body proposed to be constituted by the Supreme Court to examine the issue relating to promise of freebies by parties during elections. Saying that it is a constitutional body, the Election Commission had expressed its unwillingness to be a part of the expert panel. So what exactly happened in the court today? At the outset of the proceedings, the Chief Justice of India rapped the Election Commission of India, one of the respondents in this case, after its affidavit was published in today's morning's newspapers but not filed in court on time. Addressing Senior Advocate Maninder Singh appearing for the Election Commission of India, the CJI remarked, and I quote, "If you want to give the same to newspapers, please give it. If it reaches the newspapers, why can't it reach the court?" Referring to the ratio laid down in S. Subramaniam Balaji vs. State of Tamil Nadu, wherein the Supreme Court had highlighted that freebies have the tendency of shaking the nature of free and fair democracy, Senior Advocate VIKAS, appearing for the petitioner, suggested inserting Section 29D in the Representation of Peoples Act 1951, which could impose an obligation on the political parties to submit a manifesto on the financial implications of the promises made during elections to the ECI for its approval. Solicitor General TUSHAR MEHTA, appearing for the central government, reiterated that giving away freebies would lead the country to disaster, while also pointing out that most of the freebies were not part of the manifesto but were declared during rallies and speeches. Accordingly, urged the bench to lay down some guidelines, including the constitution of a committee, till the legislature frames a law in this regard. The Chief Justice of India, while agreeing with the Solicitor General that distribution of irrational freebies during polls is indeed a serious issue, underscored that people opposing such freebies have the right to do so as they are paying tax and would prefer funds to be utilized in building infrastructure instead. However, he added that he is not keen on encroaching upon the domain of the legislature and that the proposed committee can look into various facets of this issue. Senior Advocate Arvind, who said that he had appeared in the S. Subramaniam Balaji matter, opined that while welfare measures might be a part of the directive principles of state policy as envisaged in the Constitution, however, giving gold chains cannot be a part of implementing the DPSPs, he said. Stressing on the fact that a call for financial discipline could not be taken in court itself, Senior advocate Vijay Hansaria contended that he had submitted some recommendations on who could be the members of the proposed expert committee. While terming the issue as complex, senior advocate Kapil Sibal contended that the case can be decided only on the basis of solid data. Citing an example of women being allowed to travel for free in buses, the senior counsel contemplated while narrating an incident, and I quote here, "There was a lady who works and yesterday she said that I need money to take metro as roads were blocked due to Muharram, and when I asked her how she goes every day, she said that she takes the bus because that's free. Now is that a freebie?" the senior counsel questioned. CJ RAMANA then narrated an incident from his own personal life to highlight how freebies can also lead to illegalities being legalized. Recalling an incident wherein his father-in-law, who is an agriculturalist, had sought his help on the state government banning electricity for agriculturalists or landholders but had later regularized all the irregular connections, the CGI orally remarked, and I quote, "My father-in-law is an agriculturalist and the government had said no free power connection to agriculturalists or landholders. He asked if I could do something and I told him that this is the policy of law, and one day one irregular connection was regularized and his was not. I can't even construct brick in my house because I may violate a sanctioned plan. Next to me they are constructing floors. What is the message that we are giving?" While opining that the matter required further consideration, the bench asked the parties to recommend their suggestions and accordingly adjourned the matter for further hearing to August 17th. Thank you. Keep watching LiveLaw for more such updates.